Mr. Bonna, Gyavira, Morgan, council members joining us online, all members of Uganda Law Society joining us physically and online, members of the press, ladies and gentlemen, good morning. My name is Apio Afra. I am the head rule of law. I bring you warm greetings from the CEO, Ms. Christine Awori, who is away on official duties. I welcome you to the 14th series of the RnB Weekly Press and Public Engagements, where we discuss and raise public awareness about topical issues. We appreciate your presence and commitment to these important discussions. Today, we will discuss two topics. One, bail, grave charges and ongoing investigations, very important clarifications. Issue 2, members' welfare initiatives, ULS SACCO. To guide our discussion this morning, we are privileged to be joined by distinguished speakers, Senior Counsel Kunya and Advocate Bonna, Gyavira, Morgan. We look forward to a fruitful and engaging discussion. Once again, thank you all for being a part of this discussion. We will right away go and have our first issue being discussed by Mr. Gyavira, Morgan, Bonna.
Good morning. As introduced, my name is Gyavira Morgan Bonna. I'm a practicing advocate with GM Bonna. I'm also mostly in telecom law, so that's why most people not even see me in the corridors of court. Been practicing for about 15 years. I happen to have a very special attachment to the SACCO and the cooperative. I was the chairman of the cooperative and the benevolent fund committee during the term of Fiona Wall, and I took it on in the next term. So I've been in this for about 6-7 years. I managed to split the two because I realized they all had a different mandate and they had a different structure, and that is how I ended up splitting the benevolent fund and the cooperative. And I retained one, which is the cooperative, and handed over the benevolent fund. And both are now operational and registered. So the Uganda Law Society Cooperative. So it's not a SACCO, just to clear. A SACCO and a cooperative are two different types of entities, and the SACCO is a saving and it's a saving, it's just to save and credit, to save and then give credit. So it's a bit of a lower kind of entity. So what we decided was to register a members cooperative, which allows us to invest in things such as real estate, to invest in agriculture, to invest in money markets, to invest in a miniature bank, to invest in so many other things, own buildings. So that is why the name is not ULS SACCO, but the Uganda Law Society Cooperative. But the full name is the Uganda Law Society Members Cooperative Society. Somebody is going to say, why is the word society repeated? Because by law, every cooperative must have the name, so must have the word society at the end. So we are a society that owns a society. We are unique, we are a member society, and all the members of the Uganda Law Society, the ULS cooperative, as I'm going to call it from now on, should be members of the Uganda Law Society, fully paid up members. We have been having arguments about admitting other lawyers, because there are so many lawyers who are not members of the Uganda Law Society, but later on they become members, and they need to also serve. So people in the judiciary, we also have people in the army, we have people in the police, we have people in NGOs. So we have so many lawyers that need to be there, but also we need to look at the future and admit what you call clerks, legal assistants who have not yet qualified to be members of the Uganda Law Society, because you must be inclusive, and that's what the Kenyans have done, and it's booming. A brief background: the Uganda Law Society Cooperative is definitely a voluntary. It's a voluntary, but led by the Uganda Law Society. It's voluntary. No one is forced to join it. And it was registered on the 6th of March, 2023. We do have bank accounts that are separate, but in the names of the Uganda Law Society Members Cooperative. We do have a board that is what you will call, is usually an interim board for the first 2 years, because the licensing of cooperatives is under the Register of Cooperatives, and they give a probationary license for the first 2 years. And then after the first 2 years, you then have the full license, which we are now working on to get. And then after that, you have a substantive board that can take on the day-to-day running of the cooperative. There is nothing I can say to say that the cooperative is one of the biggest assets members of the Uganda Law Society should endeavor to join. We need to save. The saving culture is not there, and as lawyers, we are even worse off. And if you notice that lawyers are not bankable, they are not highly bankable. You walk into a bank to borrow, you will be put at the bottom of the ladder. So the best thing is for us to start our own cooperative where we can lend to ourselves and be able to uplift our lives. So one of the most important thing was in my term was to set up this cooperative. It took me 4-5 years. I've changed, we've changed a lot of members have come in, members go out, but with the board, the substantive board that was selected, I managed as the chairman to set up, and I can confidently say that we do have money. In the words of Kasaija, we also have money members. We have invested our money in money markets, and we have some, it's not a lot, but in millions. It's not a lot of millions, but it is enough for us to say we have started. We have a membership of around 200 members. We could be more. There are challenges. The challenges must be met full force. The challenges are both self-generated. By being lawyers, we are very difficult to manage ourselves. We are always quarreling. And that's the biggest problem. We fail to understand that sometimes we have to stop infighting for us to move. So the cooperatives, slow start has been because of political differences. And I've always told people, we are non-political. So whichever president comes, we must work with them. but also we are independent. But we are cognizant of the fact that we belong to the Uganda Law Society and we are members and we need our daddy to hold us. But we are independent under the law. So once we understand that this is a body that can collect money, save money, invest in real estate, invest in market money, and then also give you dividends, then it is at that time this cooperative will grow. The 200 members are not enough. We need to reach in the regions of 1,000 for us to be collecting 1 billion. And then when you collect 1 billion, I'm very sure when you come to borrow money, you'll be given the money. Right now, we are not lending. Don't come for money. We have members who, they put 50,000 shillings on Saturday at an AGM. On Monday, they were writing to me to give them a loan of 15 million to buy a car. There is no way I'm going to lend you money when we've not seen the saving culture. And that's why banks don't lend to us. Our biggest challenge has been, of course, the transition from one president to the other, from one regime to the other. The transition has not been very smooth because we've not found a structure where we can fuse the two bodies together. Two, we've not gotten monetary support from the society. This initiative was developed by the Uganda Law Society, not by an individual. They just picked me to run it. And I'll tell you, the Uganda Law Society has tried to set up a cooperative for the last 40 years. When my grandfather was the president of the Uganda Law Society, that is Justice Rnblive, he told me they tried to set it up, they failed. Fast forward 40 years later, his grandson sets it up. It is possible to set it up and it runs, and I would like every member to just do a little bit of research. Let us look at the other law societies in East Africa. Look at what the Kenyans are doing. They are trading on billions and billions of Kenya shillings in their cooperative. That is in trillions of Uganda shillings. And the members get housing, the members get medical, the members can afford to get loans to do businesses from their own society. We can do it, but we need to all come together and keep supporting the cooperative. The benefits are many. Usually what a cooperative, the biggest benefit they give is they lend to the members at a low interest. We are talking about 0.5%, 1%. Those are the interests we talk about. We don't talk about anything beyond 12% per annum. You don't talk about it. So when you look at 1%, that translates to 12% per annum. We must be below that, 10% per annum, because members want to borrow money just to do little things. And then some of the programs we've been planning, hire purchase. We've realized young lawyers, when they come into our market, they need certain tools of trade. They are necessary. We can't run away from them. A smartphone is now a necessity for a lawyer. If you are a lawyer and you have a cabinet and you don't have a smartphone, you're doing yourself a disservice. Your clients now want to send you WhatsApps with instructions. When they hear counsel is using a cabinet, they will not be able to send that immediate instructions. We receive instructions from WhatsApp now. We need a laptop. It's a necessity. It's a tool of trade that even if you are bankrupt, they will leave you with it. They will not take it. It's as good as your gown. So they will not take your gown, they will not take your law books, they will not take your laptop. You need that. But a lot of young lawyers will come, and if you lose the laptop today, and the laptop costs 2 million, I'm telling you, most people will struggle to have it replaced in one day. The whole idea of these cooperatives and all these things is for you to come and you're a member and they replace your gadget in a space of 12 hours so that you can continue operating. And that's a beauty, and it's higher purchase. You pay back, the cooperative makes money, but you have immediate relief. So there are many things we are planning, but we cannot do all these things without having members. So the 200 members that we have can sustain only a few of the programs we intend to give. And we cannot touch that money until it has reached a level where it is good enough for us to lend. So how does one join the cooperative? If you go on the website, there should be a link. I hope it's still running. My IT gurus are there. It is still there. I requested it to be there. But because we separated ourselves and we are independent in terms of money, the money should not come to Uganda Law Society, and then it is, we are subject to their annual AGM, and then we are subject to their audit norm. So we have separate accounts, and we do have account numbers. So once you go there, you can click the link and get a form that instructs you on how to join. We also have a membership form that you can download and fill in. The cooperative is so easy to join. You only pay 50,000 Uganda shillings. 50,000 to become a member. You buy one share, a minimum of only one share. You can buy many, but the minimum of one share of 50,000. And then you have become a member. After that, we encourage you to keep saving, because it's what gives me and the other team the visibility of your culture of saving, and therefore we can lend to you. If we don't see you saving, then you will not be able to convince us to lend to you, because we do not know if you will take our money and run away. So with that minimum requirement, the initial membership fee, and let me pause as senior counsel sits down. Okay. Yeah. And now that the senior counsel is settled, so with that, it's a 50, 50, 50, 50, 150. 50 membership fee, annual. You pay it once annually. Why do we need to pay it? And that's where we've always had people pulling strings. We need to pay the 50,000 membership annual so that the cooperative can have an operating budget to run the affairs of the cooperative, so that they do not dip their fingers into your savings. We have had disagreement with some of the members on that. But ideally, how do you expect the cooperative to operate with no capital? That means they won't give you reports, they won't be able to hire an auditor, they won't be able to hire an accountant, they won't be able to even pay for space. Right now, we are supposed to be hosted here. One of the deals that we made was that we'll have a seat in this place, so that we have a place where if you are looking for the cooperative, you come to the ULS house. In fact, when we are registering, this is the address that was given while it was a construction site. And when the cooperative, the registrar visited, he said, but there is no office. We said, no, it will be up there. So hoping the management of the building allocates for us only a desk so that people can come and pick information from our house. That deal I made it long time ago when I was a member of the mobilization committee, raising money for this place. I ran the call center and I made that deal. I said, when we set up, you must give a desk to the cooperative. I'm very passionate about the cooperatives. So we do have an email also that one can send to request information. So we have the info at the ulsmcs.co.ug and membership at ulsmcs.co.ug. And the cooperative, like I said, is operating. We do hope to have a roadmap to have an AGM around June. In order for us to have that AGM, in order for you, members who are listening, members who are watching, in order for you to attend the AGM, and in order for you to even stand for office, to be on the committees or to be on the board, you must be a member of the Uganda Law Society Members Cooperative, not of ULS. You must be a member. And the member, I've given you the criteria. Pay your 50,000 membership, buy one share. Even the monthly contribution saving is not as important. But once you become a member, then you can sit on the table and participate. We'll have a roadmap. We'll have the positions open, and we really, I hope the council members by then should have given us a little bit of mileage in publicity, because we lack that. We are zero funded. Zero funded. We spend our own money to set up this, but I'll tell you, we have about 50 million that we have invested, and this is 50,000 from members. And we do have some members who are so committed, every month they put in 50,000. We have members who make sure they save every month. When we are having the AGM, I will mention them. I will not mention them because I don't know how many of you are members, so I'm not going to reveal secrets. In this room, you'll find that there is no one who is a member, but out there, we know we have members. Now, communication to my members, I use this opportunity. Of course, I'm going to take some questions, and I know even members out there would like to ask questions, but let me just mention a few things, just to be as clear as possible. Some of the questions that will come, when I want to leave the cooperative, do I get back my membership fee? No. Do I get back my share? No. But your share is refundable, but transferred to another member. So you sell it, but we don't give you cash. Do I get back your savings? Yes, with the interest they have earned. For example, right now, the money that we've invested with Sanlam, and we get a return of about 12.8%. Okay, those are the returns we get. So if I was to compute, I will get the 12% and then divide it, and then each one will know how much they have earned this year. We do have committees. We have an investment committee that looks into that and makes all those decisions. Can you deposit more than 50,000? Yes, You can save as much as you want, even $1 billion, if you can prove that we are trustworthy enough to invest your $1 billion. The beauty about it is that you know cooperatives and the tax regime on cooperatives. We are exempted on certain taxes. I will not mention it because we are the president of Uganda might hear me and say, let's make a change on those things. Can you buy more than one share? Yes, but you have a limit. At any one time, no single member should own 20% of the total number of shares. At any one time, no single member, and this is a rule to every cooperative, not only us, no single member can hold more than 20%, meaning that when we have 100 shares, the total members, you cannot own more than 20 shares. You must hold 19 is the highest of the total shares of the total number of members. And you know the minimum number of members in a cooperative, for it to keep as a cooperative, it should never fall below the threshold of 30 members. So that means the 30 threshold must always be there. We are lucky we are in the 200. We've not lost members yet. Then, another question that you will ask is, when do I begin borrowing? Remember, I told you the story of somebody putting money tomorrow and then they start. So ideally, when you become a member and you have shown consecutive savings, we want you to borrow only after 6 months, because we want to teach you that you need to save. That's the whole purpose. Lawyers need to learn how to save, and they need to save regularly. Not to save today, then another day when you make a deal, you must create that culture of saving a certain amount every month. And that is that amount that dictates to us and say, this person we can lend because we can set the repayment terms and they will be able to pay back. If we don't see that, we will not lend to you, because you not have proof to us that you'll be able to pay back our money. And remember, borrowing a lawyer's money is one of the most difficult things. We are highly energized to sue. So, who determines to borrow? We have a loans committee. And all these committees are set up but need to be operationalized, because we've not lent anyway. So, like I said, you can make your deposits. We have our account numbers in DFCU under Uganda Law Society Members Cooperative, and I'm very sure without me reading them out, they will be put on the website. Now, as I conclude, then I get some questions. Times have changed. This is my call to the members. Times have changed. When senior counsel, they were beginning law, there were not more than 500 lawyers. They had a share of business. They were not haggling. They were not undercutting themselves. They followed the rules of remuneration to the dot. They were patient because they were noble men. Okay? Right now, we have thousands. We have 5,000 members. The next lot will have another 1,000. The space is narrowing. The space is becoming smaller, meaning that your clients that can afford to give you the business are also reducing because they have a wider pool. And me, who is speaking as a lawyer, I will tell you there are so many lawyers in this room who have never seen me and have practiced. And I'm here in Kololo. I'm always jogging past the building here. And I just walk below here when it's a crescent. No one Very many have not seen me. I practice in this city and I make money in this city, and I'm in a field that I took. You must be unique. Pick a field where people don't want to go. So I was a food lawyer for very many years alone. So every time you see water, there's a Q mark there. Just know that Morgan was the guy behind the laws. But I took that because no one was interested in food law. There is no money in food law. But you pick. The reason why I'm saying this, and in relation to cooperatives, because the space has reduced, you need to prepare yourselves. The day we hit 10,000 and you have no business and they are chasing you out of your office for no rent, you will remember a one Morgan who came in a t-shirt at the ULS house during the reign of Back on Track, Rnb, and told you, start saving today. It is so important. I'm 45. I have a shorter time to retire. But lawyers, we realize now they don't want to retire because they are not yet ready. You can't retire when you're not yet ready. So that's why you find that we can even practice. We can go to court with lawyers who are 80. They're still looking for money. They never saved, but they made money. But you must be cash rich, not asset rich. Lawyers are asset rich. They buy pieces of land, they do what, but they have no cash. So change that narrative. Start saving. That 50,000 today you save will compound, and that society you save in, this cooperative we are setting up, is going to outlast us. We are going to make sure it outlasts us, and in 100 years, they should be able to own commercial buildings where other people are paying them. The Kenyans are doing it, we can do it. Okay? That is my plea to the young lawyers. And the old lawyers also want to save. But my plea is mostly to the young lawyers, up to the age of 35, the ones who qualify as youths. Please do save with the cooperative. The benevolent fund can only do as much to look after you, but the cooperative will help you, one, get that first plot of land, get that first car, be able to set up a business for you, because you will have saved. It is your money that we are just investing in a group. So when you invest alone, you can't invest 50,000. Lawyers, you get ashamed to walk to the bank, line up, and pay 50,000. I do. And they say, what do you do? I'm a counsel. How would I line up and pay 50,000? But I'm telling you, when it comes to money, 50,000 is very valuable. Because if you save 50,000 and you are 1 million, those who can do the mathematics, 50,000 times 1,000 people per month, times 12 months. Look at the money that we are talking about. Now we have hit the billions. Now that becomes, you invest it, you negotiate better. When I was negotiating for Sanlam to give us the best returns, I used my ability. I am an IFA. I used my ability as a negotiator, and I negotiated a rate, a return that is better than what the rest were getting. But when you have big money, people even come for it. The Bank of Uganda would say, can you buy bonds from us? We'll give you these returns, 15, 16%. And that is where we need to go as lawyers. We can't be in a society where the borders are more organized than us. We can't be in the society where market vendors are more organized than us. We are educated, we understand money. Though we understand money, the spending, that one we understand it. Lawyers are the best. The spending we understand, but the saving, we don't understand it. We make, we spend. Save today so that you can live better. The Baganda have a saying, kolanga omuddu olyenga omugagga. Ng'omwami. I've become like the other minister. But that is my plea as the chairman of the cooperative. The hardest part, I have done it with my group. We have set it up. We are putting structures. Now we only want the members to come in and save, and even more energetic people to come in and lead it and give it an AI effect, give it a little bit of better communication, give it all these things, because we've carried the load for all these years. We can definitely move on, but we don't want to give you the cooperative when the numbers are still like this. We don't want to give it to you without the proper structures, because once lawyers lose their money, they will pick all their money and it will collapse. This thing is too good. A cooperative is too good for us to lose. In conclusion, you can always reach out. My number is very easy. I am in speed dial. When you go there, the members' affairs, they have my number. Much as I am very unknown, the people who work in this building know me. I'm a very noisy neighbor, and I'm a very aggressive man. When I want something, I come to the place and I pick it. So, my fellow lawyers, to conclude, in the words of Matia Kasaija, the cooperative is there. It is there, members, and it exists, and money is also there. Thank you very much. I sit? All right, thank you.
Thank you so much. Thank you so much, Councillor Morgan. Colleagues, money is coming. Thank you once again. We are so honored to have you here. This is very captivating. This is courtesy of the RNB. We want to take cognizance of Senior Councillor Kunya. We don't take it for granted that you have made time. We've been in touch with you and you've made time. Thank you so much. The Treasurer, you're also most welcome. We take cognizance of your presence. We are going to take questions for Councillor Morgan. I know there's quite a number that are lingering in our heads because he has said so much that is not a lot in the public domain as far as lawyers are concerned. Please feel free to ask questions. We don't want this session to take so long. Those who have questions, Council, maybe for your information, we got a question that reads, Council, you mentioned that there is a plan for SACCO AGM in June this year. Will this be the first AGM, because we never heard of one last year, and yet the SACCO was established in 2023? You can activate that.
Yeah, if the person who asked is not a member of the SACCO, they will definitely not have heard of it. But this will be the third AGM. So 2023, once you get the probationary license, you're given 3 months to hold the first AGM. Much as it's 3 months, but you hold the first meeting to confirm a board, and then you hold another after 1 year. So we held one in July of 2023, where the board was selected, and then we had one in 2024 in December, and now we are going to have one in June, so that we can now set at annually in June we'll be having one. So the mode of communication was mostly through social media, through our handles, and through the WhatsApp groups, because the members are few, 200, it is easy to communicate to 200 people, even through WhatsApp. So the notice was sent through there, but now with the Uganda Law Society being accommodative and being able to invite us, we will definitely be present at all their functions and then also announce the dates for the AGM.
Thank you so much. That is courtesy of the Radical New Bar. We thank you for taking cognizance of the fact that you've not been present, like you said before, and there's always a start to every relationship. We're so honored that at least at the back of our minds now we know it's not just the benevolent, as you said, that can only do so much, because the corporate society is going to help us even after we are done with practice in as far as retirement is concerned. My personal question, Robert Gyavira, is how long is a term of office? You mentioned something to do with different presidents coming and going. What is the longevity of a council, and what other elective positions are available for purposes of informing the members to get more interest in the idea?
Thank you. So the term, now that we get the substantive license, the term that is recommended by the Register of Cooperatives and the laws is 4 years, because you need to have a board that can invest and monitor. So when you change over too quickly, you have transitional period, change of bank accounts, change of this, change of that committee. But there is also an option of having a vote of no confidence, where in 2 years, a board can be changed, a chairman can be changed. 2, also the members can voluntarily step down. So the board members can decide, we don't want to go beyond this time. And some of the board members have expressed that, because it's tiring to volunteer. You know, volunteering is one of the hardest jobs in the world, is to volunteer and wake up every day and put all your effort in something that has no immediate return, but you're doing it for the social good. But the ones that you lead expect more from you, as if you're being paid. So their expectations are higher on you, and yet you are simply offering a service and you're offering your expertise. So the elections, yes, will be held, and all positions will be up and open, and like I said, only members will be, of course, allowed. If within this time and that time they can be 1,000 members, then better. We'll have a bigger pool. The people on my board that will be willing to stand, because the board has 9 members. And on the structure that was proposed, one of the members is a member of the Uganda Law Society, so that we can have the relationship between the two bodies. And then we have other committees, supervisory committee, we have the loan committees, and all these committees, innovation, they are all there, and but those committees are created by the board. So they are not elected. They are created by the board. But the advisory and supervisory, most of the time, will be elected. And because it is the one that audits what the board is doing. And it's the one that can check the board's excesses and check if they are following the guidelines that have been set. So the elections will be there. All positions will be open. I don't know if I will stand myself. You get gray hair when you are running these things. I'm a very young man. Senior council is looking at me saying, this young man, we've been here. But you get gray hair. Gray hair comes from stress. It is not that it is hereditary. It is the stress levels that we get in running an organization that has lawyers. An organization that has lawyers is the most strenuous organization. You have 200 smart people. You have 200 argumentative people. You have 200 people who think they can do what you're doing better. And yet every day you have to convince them that you are better, but you are also volunteering. So at the end of the day, it's a hard job, but we must do this job. You must do it because you're not doing it for yourself, but you're doing it for those people who are coming, and it's about the legacy of the man.
Thank you so much, Councillor Morgan. Councillor Morgan didn't tell you that he's also a salesman. You're doing so well. We appreciate. We shall not take so much of your time. Just maybe a reminder for clarification. There are 350,000 involved in Councillor Morgan's equation. The first is membership fee, which is 50,000. The second is annual fee, which is 50,000. And the third is to ensure that you have one share minimum. So Councillor Morgan is
I want to correct you.
Okay.
So the 50,000
Yes.
is an annual membership fee.
Yes.
That allows the cooperative to have an operating capital to run, to invest, to move around, to do whatever they have to do, the printing, everything is run under the 50,000. That's annual. Then you buy one share at 50,000. That allows you to become a member. A cooperative membership is only guaranteed by two things: by you paying a membership fee and by you buying a share. If you don't buy a share, what are you sharing? You must have the minimum share. And like I said, can you buy more shares? Yes, as long as your shares do not exceed 20% of the entire share of the cooperative. And then the last 50,000 that I said, it can be optional depending on how you manage your resources, but it's encouraged. It is the savings, the minimum savings. We don't want you to save 10K. We want you to save a minimum of 50,000 per month, which translates to 600,000 per annum. This allows us to assess you that you can be lent to and that you have a culture of paying monthly. So if I lend you 2 million and you tell me you need 1 year to pay back the 2 million, I will know that because you've been saving 50, you're good for it.
Thank you so much, Council. Thank you. We shall nickname you 50. Mr. 50. Okay, you live today with Mr. 50 or the food lawyer. Let's not forget. Thank you so much. Are there any questions that we have? Any? Okay, if there are no, we want to thank you for your presentation, Council. We don't take it for granted. We shall make sure we get your contact. Yes? There's an online question, please. Sorry. We shall make sure we get your contact, of course, like you said, from the members' affairs, and reach out. This was a general call to the members of ULS. We want to also re-echo it, and of course, we cannot overstate the importance of saving, like Council has alluded. It is more succinct in the sense that we always benefit after. Thank you so much. Yes, Council, we have an online question coming from one Brenda Anyango. It reads, the threats of taxing SACCOs are real. How radical is the ULS, she called it a SACCO, but you've already corrected that. How radical is the ULS SACCO prepared to help advocate for the prevention of the intended unfair taxation of SACCOs in Uganda? ULS SACCO should spearhead accordingly. Is that okay? There you go.
Thank you, Council Anyango. Yes, there are a lot of changes to the law that are happening. We all should also know that there is a cooperative bank that is being discussed at the moment. When we came into office, the first thing we did was announce ourselves that baloya batuse. We also want a seat with the big boys. We are not big boys, but a lawyer is very respected. So our first engagement was with the apex body of the cooperatives. It's called UCA. I met their Secretary General, and I made sure that the Uganda Law Society is ably represented in all the meetings. And here we are talking about SACCOs, cooperatives that have billions. For us, we are here in 40 million. But we are talking of Wazalendo. You're talking of the Walimu Union that has, you're talking of BCU. You are talking of Watoto. You're talking of Millennium. You're talking of cooperatives. If you just look at the one in Western Uganda, the ones that just do milk, they have billions and billions. But because we are respected as lawyers, I was given a seat with the big boys. I am afraid sometimes when they ask me, Council, how much money do the lawyers have? I am afraid to say the amount, but being a lawyer, I always know how to do it. So the question of Anyango is, how are we positioned to, one, engage on taxation, engage on policies that are going to affect cooperatives? As they get bigger, they tighten, the government tightens the noose because there's a lot of money flowing. We do sit, or I personally sit on the harmonization team set up by the Attorney General, and it is being run under the judicial, the Uganda Law Commission. And we are the ones looking at all the laws and harmonizing the laws. So the laws have been there are so many laws that are colliding. So we are trying to harmonize them. So we have Bank of Uganda, but now we had the UMPRA, but it's now closed. But we had Bank of Uganda. Then you have the Register of Cooperatives. Then, so we want to form a single entity that can handle cooperatives. The Kenyans are doing it. So you have an authority, one authority, and then you want to make sure that the cooperative can avoid double taxation. The double taxation is something that will creep in, and if we are not careful, then it is a disservice. Because the money that you give us, the 50,000, or what the farmer gives, is their saving from their income. So they have already been probably taxed. If you're being paid a salary, you've been taxed, pay as you earn, you pick your 50K, you put your 50K, then you want that 50K again to be taxed, income tax. That is double taxation, because we split, if you are going to be taxed, we split it to all the members. So that is one of the arguments that we've been making, and that's why we have an exemption on income tax. But we are given a period to make our argument. So that one, Anyango needs to know that we are there. We are working, we have money. You see, when you can't run a cooperative if you don't save in the cooperative. Me, I have my money there. But not only that, I belong to many other cooperatives and very many investment groups. And my interest is to protect my money that I have been saving for the last 10, 15 years in these investment groups. I am the lawyer for the oldest investment group in Uganda, formed in 1960. Okay? And they are so old that their average membership, the age, is 85. Yes, and the members are there, they are 90, they are few now, because of course of the age. But some of the famous ones were Professor Kakoza, a lawyer. That's the famous lawyer who was part of it, who was among the group that started it from Makerere University. So we are interested in making sure that tax does not affect your appetite to save. We are interested in making sure that double taxation does not creep in. But we are also interested in having laws that are harmonized to make sure that your money can be invested and you can get the right returns and prepare for your retirement. Thank you.
Thank you very much, Mr. 50K. Yeah, I got a question to ask for your contact because there are some people who might not have access to the members' affairs directly.
Yes, Doreen says she'll give my contact because I might give it, and but I can give it. Was it a lady? He needed to be precise. The ladies, yes, I can give them. The men, you'll find it on the website. But anyway, I am very reachable. I am a public officer, and my number should not be hidden. If you Google me, Morgan Today, on your Google, you are going to see me everywhere. And you see the other things that I do. So my number is very simple, and you can reach out, send me a WhatsApp. It's 0772 444 777. As you can see, the number means that I came to Kampala a long time ago. I'm not a villager. The number is for Kampala people. 72 444 777. You send me a WhatsApp with any information. I have prepared a form which is frequently asked questions. I will throw it there. It can answer every question, including my height.
Thank you, Mr. 50K. Is there a number for gentlemen? That one seems to be for ladies.
You don't worry, the men can also send me, but specify.
Most obliged.
Yes, you know the problem I have,
yes.
And I think because the new era allows us to not be too serious when we are talking.
Yes.
Because some men use the word dear when they are addressing. Please do not use the word dear. And say, hello dear, can you help me with... You confuse us. By the time I realized you are a man, I've already stated other things. I've also called you dear, which is wrong. So that's why we fear to give the word, the number to men.
All right,
Yes.
dear Morgan, Mr. 50K, thank you so much. We first spent on our time in regard to the first presentation. We cannot thank you more than really leave the Lord to bless your endeavors, because what you're doing is really for all of us, and it's voluntary. Maybe for you to know, there is a legal aid department that you're very well aware of as part of the ULS, and we are encouraged that volunteers are paid by God. The actions of volunteers, much as not recognized by the whole world, because it's not about money. The Lord searches your heart and pays you accordingly. So may the Lord bless you in your endeavors. It's already 3 years of effort, 2 to 3 years of your effort. May the Lord bless you, and I can assure you I am already a willing member to attend the AGM in June, and if possible, run for an elective position. courtesy of the democratization, decolonization, digitalization, and the decolonization by the the RNB. Thank you so much, dear Morgan.
Thank you.
Yeah, thank you. Ladies and gentlemen, that is done for the first topic. We would like to very fast move into the second. I would like to invite the head of department to invite our next speaker. Thank you so much once again.
Thank you, Robert. Thank you, Morgan. Ah? Thank you, dear Morgan. Our second speaker this afternoon is Senior Counsel Henry Kunya. He is the founder and managing partner at Henry Kunya and Co-Advocates. He is an expert in criminal law and has over 25 years of experience in legal practice. He majorly practices in the appellate courts, that is the Supreme Court, the Court of Appeal, and the High Court of Uganda. He served as a professional advisor at the Law Development Center for 8 years, where he was also the head of subject, criminal proceedings, and team leader, professional conduct and ethics. Mr. Kunya, you're welcome.
Thank you. I didn't hear the name, but the person who did the introduction, thank you very much. Good afternoon, ladies and gentlemen, both in the house and online. Salutations to the RNB and the administration and whoever thought it wise that I should come and say something about this. I'll start from what the lady said. I was at LDC for about 10 years, not 8. And when I look around, I think I see several of my old students. And now that I left LDC, the few times I go to court, I see many of them. And yeah, it makes me feel good that the people we're sharing with, the people who are imparting our skills, are able to come up and take the space. Like dear Morgan said, we've been around and some of us believe we should really be giving space, creating space for the incoming. And the young people, I think it is something you should take up seriously, okay? And those of you who remember, when we were at LDC, I used to tell you that if I had the power, I would only want to teach people who are going to practice, people who are going to come into our footsteps, not people who come there. And I used to tell you, for a fact, there are some people who go to LDC just to get they call it what, H popular. They put on the gown only 2 occasions. 1, when they are counsel for the week, and 2, when they're graduating. And thereafter, they don't want to know. They just hang. But the point is, it is just good that you come into the space. 25 years it has been, I think, yeah, since 2000. When I've been practicing. And when I look around, probably some of you have not yet even hit 25, but that is a story for another day. Yeah, so I have said my salutations to the administration, to the leadership, and to the membership of ULS, and that's where we are as of now, RNB. And I was invited, I must say, at short notice, yesterday by 3. That's when someone was telling me, please, you come, we have some, can you come and make some presentation? So like Madam said, I'm not an expert, but I've just been doing a little bit of criminal law practice. That's where I find, I think, some bit of space and comfort or passion. So I was given a topic which I think you've all had opportunity to look at: bail, grave charges, ongoing investigations, and then very important clarification, something like that. So there we are. I want to believe that all of us in this house, or even out there, people online, those who have had some engagement with criminal law practice, have gotten an idea of what bail is. And like I always say, it's not time for us to come and teach. We're just trying to kubaganya virowozo and trying to refresh what is it. So anyone who has been in law practice knows what bail is all about. Even the ordinary person, omuntu wa wansi, they know. Those ones who have been to court. And many times, the judicial officers actually also do so. They tell them, even those who don't have legal representation, you have a right, but depending on which offense it is, you have a right to apply for bail. So what is bail? Bail basically should be an undertaking by an accused person to go to court as and of when required. Of course, what stands behind it is that this accused person, by the time he's coming to court, chances are he has been under incarceration. He was arrested in respect of some wrongdoing. So he has been kept somewhere under incarceration. So the beauty is, he's given an opportunity. Apply for bail to court, and if court deems it necessary, they will release you so that you go out and continue with your day-to-day activities. Allow me also, before I delve into the details, as I said, I'm not an authority on bail matters. Actually, truth be told, I think I can count even the applications I've made. I don't think they're even 8. There could be about 4 or 5 only, okay? But the point is, I want to come and share with you what my views are. What are my thoughts as regards this aspect of bail? And as I said, anyone who has knowledge about the criminal justice system must have heard about bail. And with due respect, if there are any judicial officers in the house or online, allow me, I'll just probably refer to them as judicial officers, notwithstanding either magistrates, judges, justices of appeal, or Supreme Court, as the case may be. But as I said, bail will always be handy. It will be part and parcel of the criminal justice system. So the point is, someone has been presented in court, he has been arraigned. But the law is, this person should be given the liberty to go out, to continue with his life as it was before he got this issue with the court. So that should really be the basic understanding of what bail is. And we're looking at the rights of an accused person. An accused person has the right. The Constitution is very clear on this. There's a constitutional imperative. Article 23, Clause 6A relates to the application for bail. An accused person who stands charged for any criminal offense can apply to court. And the court, in its wisdom, looking at all factors put together, may grant this application. Like we used to tell this, it's not a constitutional right to be released on bail. The application only relates to, the law relates to the power to apply for bail. And with that, the judicial officer is clothed with a mandate to grant, to admit someone on bail or not. Coupled with that, also we have to appreciate the fact that bail takes dimension at different levels. You could apply for bail before trial. The law says that at any time, but I think practice has tended to show that it's very difficult. Assuming the matter is part hard, probably they've even gone to the defense. How feasible will it be for you to apply for bail? Assuming you're even a judicial officer, would you really be inclined to grant such a request? So chances are it will be sought at the beginning of trial. So the point is, when will the trial start? When will the trial commence? And that's why we bring into issue other aspects. The constitutional provision regarding presumption of innocence. Why should this person be denied, deprived from attaining that liberty or that freedom when you don't know when the case will start? When will the trial start? Okay? There are no timelines given. Those of you who have gotten an encounter with the law, you know what it means. Assuming an offense was committed, today is Thursday, was committed on Monday, what are the chances that by today, if this person is brought to court, the investigations have been concluded? Definitely, chances are they are not yet done. They have not yet even started. They have not even commenced. We know what the mandate of the DPP is. In charge of prosecutions, in charge of investigations, of course working in hand with the relevant security agencies, could be police, could be anything, anyone who is involved with the investigation. So the point is, how much time should be given to this? Yet on the other hand, this person is before court. So there is a very delicate balancing act which needs to be addressed in that regard. So we've talked about bail before trial. Now the other one, of course, we are talking of bail in any court. Could be magistrates court. We know the law, section 75 to 78 of the MCA. Then in the TIA, Trial Indictment Act, in the High Court. Okay, you are talking of sections 15, 16, thereabouts. And along the way, we've gotten guidelines. I think what they call the constitutional bail guidelines for courts of judicature, practice directions, 2022. Legal notice 8 of 2022. Trying to enforce or trying to breathe into this bail matter, because bail in itself is something contentious, something controversial, if you could say so. Because on one hand, we have what the law presupposes it to be. So where is the challenge? The spirit and the law and the spirit, what is it as regards bail? You can read, but we shall discuss this one in detail. So grave charges. I tried to comb the interpretation or whatever I could lay my hands on, but I wasn't able to come across any working definition of what grave charges are. But I would imagine we're referring to capital offenses, the matters which are tried by the High Court. Okay, there are very many examples. Could be murder, could be aggravated robbery, aggravated defilement, treason, etc. So the point is, these grave charges, how are they supposed to be handled? It begs the question, when do they become grave? Is it at the inception, because someone has been arrested, has been arraigned in court, is in the court system, because mindful of the presumption of innocence? Is it enough for the judicial officer to hold this person under incarceration? Because at this stage, chances are you've not yet appreciated what is the gravity of the offense, what is the evidence, what's the nature of the evidence that the prosecution is going to come up with. Because we say the presumption of innocence is that any person who is charged with any criminal offense is presumed to be innocent until proven guilty, that is by the prosecution, or he pleads guilty himself. So if we're looking at it from that perspective, what constitutes this gravity of this offense? Because before you as a judicial officer, you don't know. The prosecution has come, he says, we've arrested this person in relation or in connection with this offense. At this stage, is it ripe enough for you to say the offense is actually, probably let us say, is suspected to have committed the offense, and then leave the others. Then there's some aspect to do with ongoing investigations. If you look at the Constitution, as I said, I think Article 120, thereabout of the Constitution, the mandate of the DPP to be in charge of the investigations, the prosecution and all that. So that by the time this person is arraigned in court, do you have what it takes to have this person stand trial? Have you assembled sufficient evidence? And as I said earlier on, an offense is committed on Monday, today is Thursday. Chances are very high that by today, Thursday, 3 days down the road, you've not assembled this evidence. Okay? So it still begs the other question. How much time should we give the prosecution? Can you decree, can you put it in the laws that investigation should be completed in 6 months, a year? Chances are it will be very difficult. The nature of offenses, probably as we're coming in, take on different dimensions. Can you localize it, or what is the intensity, what is the investigation that you're looking at? Because it may even involve people. Who are these people who you're going to rely on? Can you easily trace them? Can you identify who they are? Where are they? Okay, so those are some. So when you talk of ongoing investigations, I think that's what comes into mind. The investigators or the people who do work with the investigations would be probably better placed. But chances are, any ordinary offense will take some bit of time. And so that's why the aspect of ongoing investigation arises. And that's why when you go to court, they're going to tell you, mention, the matter is coming up for mention. Investigations still ongoing. Investigations still ongoing. But it begs the question, for how long will it be? And what happens? This person who is arraigned before you. Because chances are that at the end of it all, you may even fail to get the evidence. That's why in criminal law practice, once in a while, you come across those incidents where the prosecution is withdrawing. So it begs the question, why then did you start with the process when you didn't know what sort of evidence you are going to come up with? Okay, so those are some of the points we'll be looking at. And now when they talk of very important clarification, I think that's the clarification we need. All of us, I think, have a hand in this. Each one of us can say something about this. So that was for the definition. Allow me to go into what I would call the next step, which would be, what is the nexus? Is there any nexus between these three? Is there any link? As they say down there, can you use bail, grave charges, ongoing investigation in one sentence? Is there any connection? Is it possible to you to conceptualize bail and also look at the gravity of an offense vis-a-vis the ongoing investigations? Or if not, what are you going to do? What solution are we coming up with? And I think this is some engagement I would propose at the tail end of my presentation. And the third aspect I want to address is on applicability. How applicable are we addressing this aspect of bail? We're looking at the experience on the ground. Among other things, we shall look at issues to do with interpretation. Because as I said, the law and the spirit are very clear. Okay? Who, when, why, and how can you apply for bail? But between you and me, you look at so many rulings. There are many decisions. And one wonders, why is it that this particular judicial officer finds issues with granting bail? Another one will not. Like Dear Morgan said, lawyers, I think, are very, very difficult people to deal with. Okay? And I think that's something you learn along the way. Because someone will make very good persuasive arguments. And a certain judicial officer will have no problem granting. And another one will not even think of it, will look elsewhere. If I could draw from personal experience, there was a matter I was handling for bail, the few bail applications I've done. And before I could even start making my submission, the judge, the judicial officer made it very clear, do you have exceptional circumstances? Have you proven the circumstances? Meaning, with or without, she wasn't going to entertain. Okay? Then another one will have no problem, because the discretion is to the judicial officer. Look through. What are the factors? What are the considerations? Are you persuaded? Has the counsel for the applicant made a compelling submission on which you can base a ruling and grant the bail as is being sought? Okay? So we're having those challenges. Of course, along the way, you get locus classicus. Some cases. In my practice, I used to share with my colleagues, I have no problem with looking at a ruling where, or even a judgment, which was favorable. Because I got it from first hand. I was in Supreme Court like you had. That's where I do a bit of my practice. And the bench was asking, the counsel who was making a submission, he was citing their own decision. So the question was, one, what was our decision in that? My lords, you dismissed the appeal. So would you want us to do the same? Then I learned something that I think, however persuasive a ruling may be, you must tread carefully. unless you are going for a very particular aspect of that ruling or judgment. Otherwise, my personal take is I wouldn't want to go for a ruling where I know bail was declined. I will not have anything to do with that one. So those are my views. I'm just sharing with you. So the point is, there are several cases, several authorities which have been used along the way. And the point is, I don't have to delve into the details. We have the Vin Patels, we have the Joseph Tumshavis, where the constitutional petition was to the effect that it was no longer necessary to prove the exceptional circumstances, which are to do with the age of the applicant, his the advanced age, the medical condition, which has to be from the facility where this person is being held. Or the other one, which I've never come across, the certificate of no objection from the DPP. All my donkey years in practice, I've never seen that certificate. I don't know how it looks like. I don't know whether it is there or it is just a redundant provision of the law. But they say the DPP can give a certificate of no objection. The certificate of no objection, the one I know is the one from Administrator Generals. But the one of the DPP, I don't know how it looks like. But anyway, I hope it is there. So the point is, what other considerations will the judge or the judicial officer be left with? Good enough, there is a position of the law. You need not emphasize the exceptional circumstances per se. So which other terms, which other considerations are you going to look at? With hindsight, there is a probability that this person will be acquitted. The prosecution may fail to prove its case against the accused person. So you must have a very delicate balancing act. Should you insist that this person should really stay inside when you don't know how soon the investigations will be completed? You don't know whether you'll even have the prosecution proving its case. And chances are the applicant, that this person, will not plead guilty. So we need to address some of those concerns. There's the Foundation of Human Rights Initiative, another constitutional petition, where they were emphasizing the discretionary powers of the court to grant bail in the deserving cases. So it begs the question, why is it that at times they are not given at all? Because the judicial officer is clothed with the discretion. The catchword there is, what are these reasonable conditions? What constitutes reasonable? And reasonable in whose sight? Okay? Now, there is also another case of Panju, say 1973, volume 1, East Africa, page 282. Because many times you go to court and the respondent, the state attorney, will oppose the application. And among other things, they will say there is a possibility, a likelihood, either of flight, this person is likely to abscond, is likely to interfere with witnesses. At this stage, the accused person probably even doesn't know who the witnesses are. For crying aloud, who are they? They are not disclosed. Probably it would make sense if there's been an attempt, okay, before probably he was arrested, or he has been sending signals or whatever it is to the probable witnesses. So the point is, under that Panju, the point is, how do you determine with certainty this possible interference? Can you prove that actually there is going to be such? Do you have any cause to fear? All right? Probably look at the other side, make it a condition. We're admitting you to bail, we are going to grant the bail, but should you interfere with witnesses or get evidence that you've done so, we shall have no option but to cancel your bail. So those are some of the things we look at. Then along the way, with hindsight, what is the fair trial? When you keep on putting this person on hold, you are not granting the bail amidst all these challenges. Okay? Are you in line with the constitutional imperative? An accused person is entitled to a free and a fair trial, to be heard within, should be handled expeditiously. What is expeditious? Is it defined anywhere? What constitutes expeditious trial? Mindful of the fact that the prosecution has to prove the case, they have to assemble the evidence they are going to put across to bring to court. We've talked about the presumption of innocence. We've alluded to that one. Then there are those elements to do with the liberties, the freedoms of the accused person. Accused that he may be, but he still remains a human being, a person who is entitled to some freedoms, some liberties. Okay? What of the interests of justice? The interests of justice, to whose benefit are they? Because there's something the courts have always been saying, there's an element of public policy. What is this public policy? Is it something you can identify? Can you define that? So it brings me now to the other component, which is to do with challenges. What are the possible challenges? We've looked at this one, the aspect of enforceability, the interpretation. We have the law as it is, the law and the spirit, but different interpretations, different rulings coming across by judicial officers. It could even be at the same rank, the magistrates or the judges. And as I said, a particular judge has no problem granting. Another one is a no-go area. Don't even waste your time. Okay? Then the other, of course, the challenge would be from the perspective of the counsel for the applicant. Are you able to meet the expectations of your client? The client will always be telling you, counsel, you do this one for me. I want secure bail. At least I used to caution my students, if they're still here and they remember. You know, at times we go to class, you think you're sharing, and kumbe, what you're saying, it comes from one ear and disappears in the other ear. But one of the things I used to tell them that, especially when I was handling another correction, by the way, before I forget, I was assistant head of subject, I was the head of subject. So put your record right. Otherwise, the people under whom I was serving would think I was superimposing or whatever. So now the point is, we are looking at the challenges that don't ever raise expectations of the applicant, of your client. You've been arrested on Monday, you have been arraigned in court on Tuesday, I'm going to apply for bail, and you'll be granted bail. It is something very delicate, at least in my experience. I think the people I try to work with or for, I never do that, because I know what it is to come. You can never claim to be the other side. You are on one divide of the courtroom. You are on the bar, you are not in the bench. So what takes you, where do you get the audacity to assure your client that I'm going to secure bail for you, unless you've constituted yourself into the judicial officer? So those managing expectation is something we need to handle with a lot of care. So I've talked about the disparities which come through. There's no sure-cut deal that you get a ruling in your favor just because you've even cited a ruling where bail was granted. The discretionary powers of the judicial officer come into play. So the last one, way forward. As I said, the intention really is to try to tickle the mind, the imagination of people who do criminal justice, who participate in this space of criminal law justice. How do we move forward? Is there a way of coming together? These are my views, as I said, my thoughts. How relevant are the guidelines we have? Is there a way of adjusting? Call it periodically, after every 5-10 years, or the case may be. First of all, can we identify who are the end users, who are the stakeholders in this? Are we only looking at the accused person? Are we only looking at the prosecution, the judicial officers? Name it. Because along the way, some of these conditions pertain to do with sureties. Probably the sureties should also come on board, should be brought on board. Why not also have a slot for the people who have benefited from bail or who were denied? What are their views? Because I get the impression that at times, I stand to be corrected, at times some of these good rules or whatever it is are made, but have we engaged the people for whose benefit they're supposed to be? Who are these people? Can we identify them? Is there a possibility of engaging, call it a stakeholders engagement? Positive, where candid thoughts come through. People give their views before we apply, and we come up with the laws or regulations or guidelines without picking the thoughts of the people who are going to be affected. What of the people who were there before? Do they agree? Because it's one thing to propose a law, but how is it going to be enforced? Will it take firm root? Will it be able to bear fruit? Or someone sits somewhere with some group or some committee or whatever it is, these are the rules, these are the guidelines, whatever it is. So I think we need to think beyond that and see if we can have that such constructive, positive engagement. And we look. For instance, when you look at the bails, as we said, what would be the other option? If you are not admitting this person to bail, and yet, with hindsight, there is a probability that this person will be acquitted. What happens to this period this guy has spent under incarceration? Okay? What happens? Then the other one is the timelines, the prosecution, like I shared earlier on. How much time do we give? Can we compute? Is it possible? If not, what is the other alternative? Can we press for quicker investigations, quicker prosecution? We know what happens in the court. On average, you go to court and there are so many cases to be handled. All right? So what are you going to do with these so many cases that you're handling vis-a-vis the rights of this accused person? And then you talk about the surety. We've talked about the sureties. It also is contentious in its own way. Who is a sound, substantial surety? Okay? Some efforts have been made to define who this surety is. There's that element of compellability. And one person would think, do we really have to go to the old day, during our days, like Dear Morgan said, when we were starting practicing, it was very easy. But now the days, do you really have to compel someone that he must be within your jurisdiction? We are talking of, you young people call it what? Global village. One doesn't have to be with you, Nikayunga, to remind you that you have court tomorrow. Okay? You can do it on phone, you can do it. Hey, Muzei, by the way, if you had forgotten, tomorrow you are supposed to be in court. But someone will say, no, you must be within the jurisdiction. Then compellability, the influence. Why is it a problem that a daughter or a son can stand surety for the dad? Then under the guise of saying, no, you see, this one is a young kid. No, this one, you must, like he said, Dear Morgan talked to you about, he said that we are becoming endangered species. So assuming the accused person is 7 years, 8 years, and for you want someone who is older than him, how many are they? The guy may have to look in the entire sub-county, will fail to get someone who is older than him. Okay, so among other things, can we find a way of relaxing on some of these conditions? You talk of cash bail. Have you tried to address the means of this person? That's why at times you have people who come in, they say, okay, fine, I was granted bail, but I can't afford the 5 million, I can't afford the 3 million. The conditions are harsh. Can you please review? So among other things, is it enough for you as a judicial officer to say, cash bond of so much? Have you tried to look through? Have you tried to address the means, the economic means, the might, the financial power of the applicant? Because it's one thing to grant and another you are denying. Okay, among other things. What of the financial status? I think in the anti-corruption court they insist, what is the financial status of the surety? Will he be able to meet? But now who is our trial? Is it the accused person? Is it the surety? Among other things. Okay, what should be the relevance of the financial means of the surety before he can be admitted as a sound and substantial surety? So we need to, what of fixed place of abode? Are you insisting someone should be confined in Naweru, Nansana, wherever he stays? The fellow moves. So what terms are you coming up with? What could be the alternative? Why should you insist that we need to get someone within the jurisdiction? Okay? But the guy is not going to stay there forever. Who knows? Probably either the applicant or even the surety can move, can relocate. So among other things, can we look at some of these aspects and see? And so what of the age? The LC letter. Of course, I don't want to say the bad practice, but there are some courts where you hear of professional sureties. At times, the judicial officers actually have good eyes. Either they keep on seeing these people. Today he's Byamgisha, tomorrow is Okello, another time is Mangeni, and the same person. Somehow they'll get those LCs, letters, they'll get IDs, whatever it is. How they do it, I don't know. So can we look beyond? These are the considerations. And the role, of course, would expect every shooter to know why they're doing that. The relationship, why should the relationship be a big issue? Why someone appreciates what he's undertaking? Why should it be very critical that you must have an established relationship? If you are challenging that, then at least let us propose. So it goes down to the same thing. Can we have a way, probably some meaningful engagement? Otherwise, the world keeps on revolving, things are changing, but somehow along the way we seem to be stuck. These are the parameters we should be considering. So I think we need to address some of them. So I'll end up with those of you, since we're in the Holy Week, some of you need to be reminded, tomorrow is Good Friday. Those of you who are a bit spiritual, you probably know Ezekiel 37. Anyone who knows Ezekiel 37? You don't read your Bibles, eh? It's about what? Very good. You read your Bible, Wamba. You are not like the others. The valley of dry bones. So can we find a way of speaking to these dry bones affecting our bail system, bail procedures and processes? Because as I said, we have the spirit, we have the law. But how come we have these disparities? So can we find a way of breathing life into this space so that we give meaning to these things? And along the way, people will know with certainty, I'll go to court and chances are I'll get bail. So with those few remarks, I wish to thank you. Thank you for listening to me. And I think I'll be at hand to take any questions, if any, or if you are convinced or you are confused, it's also okay. Thank you very much.
Thank you, dear Senior Counsel, for being very perpendicular. We appreciate you following in the footsteps of Counsel Morgan. We thank you so much for the opportunity and for the wisdom that you've shared. Ladies and gentlemen, we have also had our second question answered, and we believe there are questions and we are ready to take them for Counsel. Counsel, we are a very big lot out here, proud of you. You are our lecturer, like you said. We just didn't hear the word wacha, the way you used to train us. Thank you so much for making it a light moment all the time and for taking us through that phenomenon topic, which is always a question that has answers complete. Any questions, ladies and gentlemen? Yes?
Thank you so much, Senior Counsel Bonna. I have two questions. The first one, how is bail referred to? Is it referred to a right to apply to bail or a right to bail? The second question is relying on Article 23(6). Article 23, sub-article 6, paragraph B and C. Does it provide for mandatory bail? And if so, can that mandatory bail be still on the discretion of the judicial officer or not? Thank you.
Thank you so much. Counsel, you can activate that microphone next to you. You can activate that microphone, please.
Okay, thank you. Bail, you are talking about the rights. We said according to the Constitution, it's very clear. And the Constitution under Article 23, Clause 6, as you said, gives the right of an accused person who has been arrested in connection with any criminal offense to apply. And that's why I say that it's not your right, it's not mandatory that you will be released on bail. What the law says is you are given the right to apply. That's why no one, I think, will be shut out. They can never say you cannot apply. It is your right to apply. So it's the other one of the right to bail. It has to be balanced. That is why the judicial officer's discretion comes into play. And as I said, they are clothed with that discretion. As to whether they will be able to grant or they are persuaded is a story for another day. But you, as counsel for the applicant, or even the accused person, you are not locked out. You can apply. That's what the law says. On the second one, the mandatory bail. Thank you for that one. It skipped my mention, but I had it in mind. That the law also presupposes that, as I had shared with you, chances are that by the time this person is arrested, is incarcerated, the investigations are not yet completed. So if it is a capital offense which calls for trial in the High Court, this person must be committed. And the law is that, that is under Article 23, Clause 6, as you are saying, that if you've gone 180 days, that's 6 months, without committal, this person should be admitted on mandatory bail. But the guidelines which I refer to now are to the effect that actually this person, the court should ordinarily send the file to the High Court. And it is the court which is going to grant to admit and look through. Do you satisfy the conditions before you do? But back in the day, it should have been, that is my view, it should have been that once you've clocked 180 days, chances are the prosecution has not gotten the opportunity to assemble sufficient evidence. So it goes down to the same question, why should this person be deprived bail when you are not committing him? Okay? But now with the new practice directions, the chances are you must forward the file to the High Court. The court should be able to see through and then do the necessary steps. So the point is, why should it come to that? Because on one hand, you've been given, that's why I was asking the question, how much time do we give these people? But we're talking of 6 months, which should be the average for committal. Committal, not that this person is going to walk scot-free, but committing him from magistrate's court so that he goes to the High Court. Yeah, so.
Thank you so much, Senior Counsel. Senior Counsel, there are 2 more questions. I hope you can still take some. Flavia is asking, some critics raised questions in regards to Besige's bail denial. Many say judicial officers are departing from precedent. What is your view about that ruling? Is it clear?
What is my view on what?
About the denial of Dr. Besige's bail.
Okay.
Yes.
I respond?
Yeah, sure.
Okay, thank you. Well, as I said, should I call it a gray area? Because, as I said, the law is what it is. The question comes in with the interpretation. How come a judicial officer will have no problem granting bail, and another one will think otherwise? Because the law presupposes they're given the discretion. That's why it goes down to what I was suggesting. Can we at some stage, either ULS or whoever can organize that, have this positive engagement? Bring on board the judicial officers who have been handling these things. They can share with us. Why is it that in such a case they were able to grant and another they were not able to? Because the law is they are given the discretion. So how are they exercising this discretion? Have they looked through the factors, the considerations before bail is granted or denied? Have they been alive to those other constitutional provisions? The right to a fair hearing, the presumption of innocence, the freedoms, the liberties, etc. So the point is there is a mismatch of sorts, if I could say that. Because you have the right, as I said, the law, the spirit, very clear, but the interpretation. And that's why we're having those issues of the precedents. And I was very clear in my presentation. Some judicial officers will have no problem. You'll even cite a ruling, and the judicial officer, with due respect, departs. Everything else is in agreement, but somehow, somewhere along the way, thinks otherwise. So is this the judicial discretion? Are they exercising their discretion? Because now you can't put yourself in the shoes of the judicial officer to find out why did he or why did she not grant. And yet you laid bare all the considerations you thought were compelling and should have resulted in a grant of bail or admission on bail. So that's why I'm saying that I think at some opportune time, if it's okay with them, either in-house or in closed doors, they can probably come on board and share with us. Why? It is becoming a challenge because on the first of the record, someone really thinks, I've really come up with all the grants, all the conditions I've met. Why shouldn't you grant bail? Why are you engaging into speculation, as I said, or whatever it is? So I think it is better addressed by the people who have been failing to grant the bail. Otherwise, for me, in my humble way, I think I cannot answer that one very well. I just give my views.
Thank you. Thank you, dear Senior Counsel. Senior Counsel, last week we had an advocate, and I believe because you are an ardent follower of RNB, for which we actually want to give you flowers, may we please give Senior Counsel a round of applause? Because Senior Counsel is one of the ardent followers we have, especially online, alongside Senior Counsel Philip Karugaba. Last week we had an advocate by the name Amos Kuku, who was discussing cash bail. And he gave an opinion, and which was, of course, telling and a little succinct. He was of the view that cash bail is unconstitutional and it violates the right to equality. You might not believe that you yourself are senior, because we take you as a senior counsel, and your words to us are very serious. Your opinion informs our reasoning because of the years of experience that you've alluded to. What is your view about cash bail and its level of inequality, just in the view of Advocate Amos Kuku, who is not here, of course, but, well, we are sharing ideas and we're trying to trigger the mind in regard to this topic, which is very, very controversial, like you said. Thank you.
Okay, thank you. I think in my presentation I did allude to a bit of these cash bails, among other things, saying that probably these are some of the areas which call for some bit of reform. So if at all at some time, God willing, our Muslim brothers and sisters say, Inshallah, if that time ever comes, among other things, we could brainstorm what forms the opinion of a judicial officer in slapping or imposing this cash bond. Like I said in my presentation, have you been able to assess or confirm the financial means of this applicant before you impose such a sum? Are you sure he's able to do that? Because if you don't, then chances are you are really giving with one hand and depriving with the other. Okay? So it goes down to what you said, that aspect of inequality. It will come to a point where out there people think bail is only a preserve of the people who have the means. Because you talk of 5 million, 10 million, whatever, they're going to pay. Yet someone else who is less privileged, probably for no reasons of his own being, his own take, is not able to meet that. So, like I said, is there a way we can revisit and think of other areas so that we have on board? Because the law is very clear. The sanctity of the Constitution, all people should be deemed to be at par. As to whether it is real or it's not, that is a story for another day. But at least let the law be seen to be emphasizing that. So if you're talking of cash bail, what forms your opinion before you impose that cash, among other considerations? If not, what could be the alternative? So that's, we address these ones. So it goes down to the same thing. Can we have those periodical engagements? How relevant are these terms? Should we really stick to what it was then, is now, and never shall be? Or we have time to adjust with time, and as the circumstances keep on changing.
Thank you so much, Council. Lastly, Mohereza Javin states, the bail guidelines practice directions were passed in 2022. Have these guidelines adequately guided on the subject of bail, or are these loopholes or areas that need to be addressed? Are there loopholes or areas that need to be addressed that the law did not cover? Thank you.
Okay, thank you. Same story. When you talk of guidelines, I know there's some school of thought which has it that guidelines remain guidelines. Actually, I remember I've been to court where someone wanted to raise it, and someone said that until otherwise decided, I think there's even, if I stand to be corrected, a constitutional petition in that regard. How enforceable are these guidelines vis-a-vis the substantive law that we already have? Because on one hand, the guidelines come in and the presumption is they are trying to really guide on how bail should be handled. But in so doing, are they buttressing the processes, the due regard of the law, or they are a hindrance of sorts? So it will go down to the same thing. Can we find a way of reviewing, reflecting on these ones, periodically or otherwise? Because there could be loopholes. And I think the law, like Dear Morgan said, lawyers are very, could I say, cantankerous people. They always think through so many things. They'll even create the loopholes, probably which are not there, but because that's what they really want to. Okay? So the point is, how do we look at this? Because it would be very dangerous, if I could be permitted to say that, if we maintained or we thought that the guidelines, or no, the rules or the processes regarding law, bail, should remain static, because we're having evolving times. Okay. Now, if I could give another example, if you are talking of cases to do with anti-corruption, probably some of them 3-4 years or so, but how long is this person on remand? Chances are, if he doesn't, by the time you even finally start with his hearing, he has already spent 4 years there. Now, what is going to be the maximum? By the time he's standing trial, chances are the sentence you would have imposed against him has already been served. So we need to be, I think, very alive. Nothing is static, and we can keep on. Let us, I think, have a very open approach, open mind. The issue is stakeholders. Whose views are we eliciting? I want to look at the prosecutors. I want looking at the accused persons. It could be that the policemen, also the investigators, have their own concerns. Can we bring them on board? Why is it that people stand trial forever? They wait forever. As I said, why should you come to a situation of mandatory bail? Someone is on a capital offense, but it is 8 months, and been committed. So, what message are you putting across? Do you really have the evidence? If you have the evidence, sure, there's no reason why you should fail to commit someone within 6 months. Committing. So, why should it be a challenge, really? So, we need to really address our minds to this and find a way. Thank you.
Thank you, dear Morgan. No, sorry. Dear Morgan.
So that one, the dear is only for him, eh?
Yes. Senior Counsel, we are very grateful for your wisdom. We don't take it for granted. We thank you so much for encouraging us to undertake our mandate under the ULS Act in Section 3D that gives us the mandate to protect and assist the public in Uganda in all matters touching and ancillary or incidental to the law. We are on course, and with you blessing us like that, we have no doubt that we're on the right track, back on track. Thank you. Before I end, there is a question that has come again. from Brenda Anyango. We thank you, Brenda, as you keep to watch us. It says, ULS should share the history of criminal justice system in Uganda, including the Penal Code Act and the Trial Indictments Act, clinging onto colonial laws to keep the interests of those in power. Kindly, I request for the highlight of the nexus between the topic and mandatory bail. Does the gravity of the offense, exceptional circumstances, substantiality of the sureties, and or cash bonds apply, or is it relevant at all? What is the difference between grant of bail and admission on bail? It's quite detailed. I hope you picked something, Council.
Okay, thank you. I think the first limb of it is addressed to the Law Society. I will not venture into that, the history.
Sure.
So I think Brenda was talking about the relevance, I think the connection, the nexus, the mandatory bail, the sureties, exceptional circumstances. In my presentation, I tried to really handle them in one way or another, but what I was raising out is the law as it is. Mandatory bail, like someone in the audience brought out. We thought, one would really think that it is what it is. You failed to commit this person within the statutory period, meaning he should be granted mandatory. That's what it means, implying actually with no conditions. It's mandatory. But now the point is, it is being referred to the High Court to be handled now like any other form of bail. That's what it would come to. Because at the end of the day, the judicial officer has to look through the application and find merit, whether to grant or not. Okay? Yet, on the other hand, we will have what we call mandatory bail. So it poses the question, what is mandatory? Okay? Because one way would be that mandatory presupposes this person has already met the threshold. So admit him on bail. But by the guidelines, the impression created is still go before the judicial officer, who is this time the High Court. And then he looks through, or she looks through the application to find merit to grant or disallow the application. So those are some of the areas we are talking about. Some sort of exceptional circumstances. Like I said earlier on, you are talking of a condition. Probably it has now brought, this one has to come out. You are talking of the medical condition. Is it enough for you as a judicial officer to limit yourself to what the prison authorities are saying? Is there a second opinion? Is there a possibility for a second opinion? Or you leave it as it is? So that's why I'm saying that I think at the tail end of it all, whenever it will be just imperative that we create space and have that positive engagement. So that people who have been through this really come on board and they give their thoughts and shares of this. What is doable, what is not. What is applicable and what is not. And then you talked about the grant of bail and admission. I think the good Baganda said, "Jona bikola chimungachi nga samona." So admitting someone on bail, granting bail is the same thing. So don't need to go into the details of that one. It is all samona.
All right, thank you so much, Senior Counsel. Once again, we have come to the tail end of the discussion about bail. Counsel, once again, would like to acknowledge your input and thank you so much for standing with the Radical New Bar. We pray that the Lord bless you, especially through this period of time of Easter, as you've already blessed us, and beyond that. Thank you once again. Ladies and gentlemen, thank you for standing with us. We don't take it for granted. We appreciate the time. We'd like to move to the last item on the agenda. I'd like to invite the head of department to take us through the next item. Thank you.
Thank you, Robert. Thank you so much, Senior Counsel Kunya. And thank you so much, dear Morgan. I now take this opportunity to invite our treasurer to address us. Thank you.
Good evening, everyone. I'll take little time since I know it's lunch time, so I know the moods are changing. But let's make another round of applause for our panelists, please. Let me also convey greetings from the council members, specifically from the president, who is currently in Germany on official duties. And also specifically from Council Edman Nangulu on the weekend as part of the society's corporate social responsibility, giving back to the community. The society officially launched the waiting area in Mbale, where the dear mothers who are waiting to initiate new life in the society are pampered until that stage is finally handled. So, greetings from the Eastern region and also from other council members. I would also like to thank the organizing committee for ensuring that on every Thursday or any other day of the week, we successfully have this Rnblive aired out. The online team, thank you for the service that you always deliver. And all the members here, the radio reporters, TV reporters, the members, the Uganda Law Society members, really acknowledge and we thank you for sparing time, the secretariat team. We thank you so much for that input that you make. For our panelists, thank you so much for sparing time. We don't take this for granted. It is not obvious that you're supposed to be here. You spare your time and you come and deliver to this nation. Senior Counsel, specifically, I thank you. You really did a good job in me. He was my lecturer at LDC, and I believe I am what I am because of Counsel Kunya, the guidance. I really appreciate. The entire members of Uganda Law Society really appreciate the services, the guidance that you have always given us. Also, Counsel Gyavira, I had an interaction with you. For those who don't know, Counsel Gyavira is the pioneer of the Benevolent Fund. He's the pioneer of what we call the SACCO. He's the man behind those two ideas, the ideas that benefit the members entirely. As you all know, at one point in our life, we always have hardships financially. So the Benevolent Fund came in to assist members. But when that time comes, you can always have someone to assist you. Yeah? A fund that can always cater for those medical, worst case scenario when you depart from this world. There can always be a fund that can assist your family to ensure that you have a send-off, a proper send-off. Like he has clearly stipulated, becoming or enjoying the benefits of those the fund, the Benevolent Fund, and the SACCO. You need to be a member. Just like you need to be a member, you need to subscribe to become a member of Uganda Law Society annually. It is the same way you need to do with these entities, the Benevolent Fund. That is why we always put a fee. We put a fee during the AGM. We agreed on a certain fee that members should pay a certain portion of money to enjoy those services. Remember, we are as strong as the unity we achieve or we bring together. So at that point, I really call upon all members of Uganda Law Society, please let's become members of the SACCO. I know it's not the right word to use, but I think that is what members of Uganda Law Society are used to. Let's become members of the SACCO so that we can achieve bigger goals. I was in Kenya, I was in Tanzania, and they have funds as big as Kenya specifically. It's bigger than 1 trillion shillings. So when you have challenges to subscribe as a member, you know the year can be challenging, especially at the beginning. You have challenges of coming up with funds to subscribe as a member. You can always run to that entity. So it is something that we should look at, and we should see the benefits that come with being a member of such a society. Senior Council has clearly elaborated on the issue of bail. As Uganda Law Society, we are very clear on the issue of bail, especially the current case about Dr. Kizza Besigye and Haji Obed. It's not because that Uganda Law Society has an inclination on Kizza Besigye or in any political matters. We are only in this issue because of the fundamentals, the bedrock of this nation, which is rule of law. Uganda Law Society, we believe that judicial officers, in whatever they do, they should always align with the law. It is only the law that will save us as members. Judges, remember that at the end of the day, you're going to revert back to the society. In a few months, a few years, it may look huge, many, but at the end of the day, you're going to become a member of the society. And you'll understand what we say. You'll understand the grievances of what we say. Some of the members, before they become judicial officers, really understand the cause, but really don't understand. Once there is a crossover, they tend to get a blind eye, a deaf ear. They tend to ignore and think that we are being too radical, too demanding, too pressing. No, we're not too demanding, we're not too pressing. So, on the 14th of April 2025, through our Vice President, Mr. Anthony Asimwe, we made a very clear statement in respect to bail issues. We really condemned the ruling of the Honorable Justice Rosette Comfort Kanya. We believe that her ruling was in violation of the law. Senior Counsel Kunya taught us, the conditions of bail are very clear. But you have to prove the following elements or the following grounds for you to be given bail. So for someone to convince, because the judicial officer was very particular on that, she said that they have satisfied all the grounds for allowing bail to be granted. But she went ahead and denied bail. Now we are setting a very bad precedent. Remember, the law of precedent, the doctrine of precedent does apply. So another judicial officer is going to apply the same principle. Now it is Dr. Kizza Besigye, tomorrow it is going to be someone else. And before you know it, we no longer follow the law, we follow people's opinions. Denial of bail should never be speculative in nature. In other words, don't bring in elements of speculation that so and so is going to interfere with investigations. The law has always been clear. People should give evidence to prove whatever allegations they say. If you say someone is going to interfere, bring evidence. Let it be easily seen in the minds of an ordinary person that indeed this person is most likely to interfere. Maybe you can talk about the history of that person. He has a history of interfering with justice. But denying justice on speculation is unwarranted. It should never happen. It should be stopped. We urge judicial officers out there that never deny someone a right on the basis of speculation. Remember, your judicial discretion is not absolute. It is not absolute. It has to be backed by certain laws. You must be confined within certain laws. Otherwise, this is going to fracture the entire foundation of this society. The foundation on which our forefathers the ones who fought and those who did not fight envisioned. They envisioned a world that is governed by rule of law, a world that is free, a world that is fair. Even when you are sentencing, even when you are denying someone a right, you should be seen to be fair. You shouldn't do things that are perceived by people as being unfair. Remember, the person you are denying a right is someone's father, is someone's brother, is someone's, name it. So, you may make a decision saying, after all, this person here they've just brought into me, I don't even know the person, let me take whatever decision I want to make. So, lastly, we call upon all divisions of court, in particular the civil division of High Court, please expedite the matters of Uganda Law Society. We have matters that we have filed in the High Court, and in particular, the matter staying execution proceedings against the president of Uganda Law Society. This is a very pertinent issue to all members of Uganda Law Society. Please expedite this matter. Just like you expedite other matters, please expedite this matter. The president is your president. When we interact with the judicial officers, they confirm that indeed they are also members of Uganda Law Society. They subscribe every year. Can you believe it? We have judicial officers who have been on the bench for more than 20 years, but they subscribe every year. Every year they come and pay subscription fees. They are members. So members of Uganda Law Society who are on the bench, please expedite the matters that we have before you. This is not a command. Let it not be perceived as a command. We urge you, as our brothers in that area, to please look into that request. We would also like to thank the Honorable Justice John Mike Musisi, who is handling our Court of Appeal matter. He has really handled the matter very, very professionally, and so far we are moving on very well. I believe in not more than a longer duration of time, we shall be getting the fruits of our submissions. I know both parties have filed their submissions. We shall get the fruits of our submission. So I will end by thanking each and everyone for sparing time to join us. Remember, we are setting history. You know, when they say that in 1986, when people say that we fought in 1886, some people think that they are trying to show off. But there comes a time, a historical moment that is before you, and sometimes you may not see it. This is a historical moment. When we say the radical new bar, we mean what we say. These are not just words. People, these are not mere words. When we say radical new bar, we are not just coming up with English terms to complicate communication. We mean what we say. We are going to be very radical. We are going to ensure that we cause change in society. We shall ensure that policies are aligned with the current aspirations of the society. So I would like to wish our Christian brothers a very happy, festive Easter season. I know starting with tomorrow, I think even today it's Holy Thursday. So I really want to wish our Christian brothers a wonderful festive season. Thank you so much for listening to me. I think at this juncture, I will invite the MC to tell us what next.
Thank you so much, Treasurer. We've come to the end of today's R&B. Thank you all so much for coming. I wish you all a blessed Easter weekend. May He rise in each and every one of us. I now call our panelists for a photo moment.